My name is Erin O'Toole. I'm the court administrator at the 8th District Court of Appeals, and I want to thank Case Western for partnering with us again this year. They've been very supportive, and we really enjoy putting on the seminar, which is a lot of work, to which I want to also thank our Court of Appeals judges and staff who put this together for you, and it's at the right price, free. So in this segment, because it's lunchtime, we want to keep it more interactive. So please, these are going to be the landmark Supreme Court cases from the Cleveland area. And we have the honor of having Professor Jonathan Enton, who is the David L. Brennan Professor Emeritus of Law at Case Western Reserve University, teaching us about this. He has a very distinguished bio. That's in your material, so please take a look at it. But to highlight a couple things, he's published over 150 articles, books, chapters, essays, and reviews, appearing in prestigious publications at schools as Harvard, Yale, Columbia, Northwestern, and Texas. He also has been published in a number of social science periodicals. I think this is going to be a great presentation because among his many awards, 5 graduating classes honored him as the Teacher of the Year. 2 other classes selected him as Administrator of the Year, and the Law Alumni Association gave him its Distinguished Teacher Award. So I feel like we're going to get a great education here today about all these landmark cases out of our area. Also, I was impressed to learn that he was a law clerk to Justice Ruth Bader Ginsburg when she was a judge on the U.S. Court of Appeals for the District of Columbia Circuit. And he did appellate litigation at Steptoe and Johnson in Washington, D.C., where he helped to exonerate an innocent man who came within hours of execution. And when I was speaking with the professor prior to his presentation, he noted that as one of the most significant things in his career, which I think is very telling given the impressiveness of his resume. So without further ado, we are going to take calls or questions from Zoom. So please submit your questions that way as well, because I understand we have a large Zoom audience. Thank you, everyone.
Thank you, Erin. I feel like what I'm going to talk about, some of you probably know more about some of these cases than I do. So I do want to encourage questions and comments as we go along. I'm honored to be here, if only because we hear a lot these days about the disjunction between the bar and the legal academy, and programs like this bridge a big piece of whatever gap that may be. Thank you for having me. Now, as the title of this talk indicates, a fair number of important Supreme Court cases arose in Greater Cleveland. I first became aware of this after I arrived here to join the faculty more than 40 years ago. Until that point, I had never been in Cleveland except to pass through. That's not an editorial comment, it's just like I never had occasion to be here. Now, to put it kindly, I am directionally challenged, so I have a really hard time finding my way around. And sure enough, I was having trouble navigating around Greater Cleveland. But then I noticed, as I said, a fair number of important cases arose in Greater Cleveland. And so I decided that maybe I could get a better sense of the geography if I figured out where, the sites, that's sites with an S, not sites with a C, right? But if I could figure out where some of these cases happened, I'd have a better sense of the layout. So I did that. And then in the spring of my first year on the faculty, I was asked if I would contribute something to the annual faculty auction. And so I decided this might be different from, say, the typical host some students for lunch or dinner or something like that. I mean, those are a lot of fun, but I figured this might be sufficiently different, and it sort of took on a life of its own. So I have done this tour. I've done this legal history tour almost every year since I've been here. Today is a little different because usually I do this in a motor vehicle of some sort, and we are actually driving around. Sometimes the vehicle is a car. Sometimes it's a van. And a few years ago, it was a bus because somehow Chief Judge Sutton of the Sixth Circuit found out about this tour, and he wrote me into giving it as part of the Sixth Circuit Judicial Conference. So this is going to be a little bit different in a couple of ways. First of all, we're not moving. And that means that, at least I'm not, I don't know about you all, but when I do give the tour as a mobile event, it's organized more or less geographically. I'm going to stay a little bit with geography, but today, because we aren't constrained by geography, I'm going to try to organize things as well a little bit along substantive lines. Now, so let's start maybe with perhaps the biggest case that that we have had around here, and that's in the zoning area. The landmark Supreme Court case on zoning is Village of Euclid against Ambler Realty Company back in 1926. Now, a little background. Zoning actually began as a device to promote residential segregation. So we had in the early years of the Great Migration, where a lot of African Americans were moving from the rural South to cities and up north, a number of cities like Baltimore and Atlanta enacted zoning ordinances that, as a practical matter, made it difficult, if not impossible, for Black folks to live in traditionally white areas. Now, the U.S. Supreme Court rejected Louisville's racial zoning ordinance in 1917 in a case called Buchanan against Worley. That did not stop efforts to promote residential segregation, but that's a subject for another day. Meanwhile, New York City adopted the first comprehensive municipal zoning ordinance in the country in 1916. That ordinance was ultimately upheld by the New York courts. It never got to the U.S. Supreme Court. So the case that actually got to the U.S. Supreme Court was the ordinance in Euclid. And if you look here, I don't have a pointer, but you can kind of see the green stripe on this map that goes southwest to northeast. That's Euclid Avenue. And that's the front of some acreage that Ambler Realty owned. On the west end of that plot was East 196th Street. On the east end, it was East 204th. And the lot actually went back to the railroad tracks, which were the nickel plate railroad tracks. This was a great case, not just because it was the first zoning case to get to the U.S. Supreme Court, although it was. It was a great case because of the lawyers involved. The ordinance had been written by James Metzenbaum, who was the older cousin of Howard Metzenbaum, who served for many years as a U.S. Senator. On the other side, representing Ambler Realty, was Newton Baker, the Baker of Baker Hostetler, a former mayor of Cleveland, former Secretary of War under President Wilson. Now, when the case got to the court, it was argued in early, uh, 1926. Justice George Sutherland was not able to participate in the case at that point, and the court deadlocked. So the case was re-argued in the fall of 1926. This time, Justice Sutherland was there, and he wrote for a 6-3 court upholding the facial validity of the Euclid zoning ordinance. Sutherland analogized zoning to nuisance law. And he said, in nuisance law, we figure out whether a nuisance exists by considering a building in connection with the circumstances in the locality. He said, a nuisance may be merely a right thing in a wrong place, like a pig in the parlor instead of in the barnyard. And then he added, if the validity of the legislative classification for zoning purposes is be fairly debatable, the legislative judgment must be allowed to control. And so Euclid is the case that made it possible for cities around the country to engage in zoning. Not every city that does zoning does it the same way Euclid did. There's plenty of ongoing debate about zoning, but Euclid is a really important case in this area, because the entire history of American land use regulation would have been quite different if Euclid had come out the other way. Now, next case is City of Eastlake against Forest City Enterprise. This is a 1976 case, sort of a special for the 50th anniversary of Euclid. Eastlake is actually the third zoning case that the Supreme Court took. It took after Euclid. 2 years later, it had a case called Nectow against the city of Cambridge. That case said that there were some circumstances in which a zoning ordinance as applied would be unconstitutional if it deprived the owner of all economically valuable use of the property. And then for the next 48 years, the Supreme Court did not take another zoning case. Well, so this is the Eastlake City Hall. It's the best sort of site that I can think of for this case. But a little bit of background here. Forest City Enterprises wanted to rezone some land that it owned in Eastlake so that it could build a high-rise apartment complex, which would have been a new type of building in the city. And as a result of the controversy that arose from this proposal, the city amended its charter to require that any rezoning decision approved by the zoning board would be subject to a popular referendum, and the rezoning would be allowed to go through only if at least 55% of the folks who voted in the referendum voted yes. Needless to say, Forest City was not happy about this, and they challenged this in the state courts. And Forest City actually won in the Ohio Supreme Court, because the Ohio Supreme Court said that this kind of classification that we're talking about, rezoning was a legislative act, and the city government could not delegate its legislative power. It had to exercise that power by itself. Now, that subject of what legislative power in what circumstances might be delegated has been an ongoing source of debate at the federal level. And I think that particularly in light of the result of the last presidential election, and the fact that several current Supreme Court justices have suggested that they're interested in reinvigorating the non-delegation doctrine, I think we're going to see some cases on those lines. I'm not in a position to predict how they will come out, but I think it is safe to say that non-delegation is going to come back as an issue. Now, so the city, having had its charter provision invalidated by the Ohio Supreme Court, took the case to the US Supreme Court, and the US Supreme Court said there's no unconstitutional delegation of legislative power here because ultimately authority rests with the people. And this charter provision simply confirms for the people that they have the ultimate power. So no constitutional objection here, the court says. Now, Euclid, or not, Eastlake comes back in a way a few years ago. Some states have independent redistricting commissions. The people in Ohio just rejected a proposal for that here in Ohio. But in 2015, the Arizona Independent Redistricting Commission was challenged on constitutional grounds. And the Supreme Court said, well, and the theory was that the Constitution says that state legislatures are supposed to determine the ground rules for voting. And the argument was the Independent Redistricting Commission wasn't part of the legislature. That was indeed the whole point. The Supreme Court said that, well, Arizona, like Ohio, vests ultimate sovereignty in the people. The people adopted the Redistricting Commission through an initiative and referendum process, and that was sufficient to bring it within the legislative power. It's the same kind of reasoning that the Eastlake Court used in upholding the 55% supermajority requirement for rezoning in that city. Now, third case in zoning, Moore against the City of East Cleveland. East Cleveland had a really complicated definition of a family for purposes of its zoning ordinance. Only a single family could live in a unit. And it turned out that Inez Moore had a complicated family arrangement. She was in the house, and she lived with one of her sons, a fellow named Dale, his son, Dale Jr., and another grandson, John Jr., who was the son of her other son. And under the terms of the zoning ordinance, because the two grandsons were not siblings or pure siblings, right? He couldn't live in the house with them. And so the city authorities cited her for violating the zoning ordinance. Basically what we had was the two grandsons were cousins, not brothers, and that ran afoul of the ordinance. Now, I can't show you exactly where the house is. I used to drive past there. The house is long gone. As I recall, and I subject to correction, I think that this vacant area in this picture is where the house had been. It's actually not very far from here. It's less than a mile. It's over on Garfield Road in East Cleveland. When the case got to the US Supreme Court, the court said it was a 5-4 ruling, and it was 5-4 because the theory basically was that the zoning ordinance violated Inez Moore's substantive due process rights. And those of you who remember your constitutional history know that substantive due process came down to us, particularly from the early part of the 20th century up into the 30s, with a kind of a bad reputation. And so there were some justices who, as a matter of principle, simply would not rely on anything that looked remotely like substantive due process, even though the dissenters in this case actually had a lot of sympathy for Inez Moore. They just thought that it was inappropriate for for the court to rely on substantive due process to strike down anything based on that history. Okay. Now, let me turn from zoning to criminal procedure. And the first of these cases is, of course, MAP. Now, my wife and I used to live maybe half a mile from the house where Dolly Mapp got busted. And I once walked her over there to show her the house. And we were greeted by a boy who couldn't have been more than about 8 or 9 years old. And he saw me pointing at the house, and I think justifiably wondered whether I was casing the joint or something. And so he asked me if we needed help. And then I thought for a second, this is actually an obscenity case, and I will explain it in more detail in a second. But I'm thinking, now I'm going to tell an 8 or 9-year-old kid about obscenity. So, you know, I thanked him. I just said something really famous happened here a long time ago, and we were just noting that this is where it happened. Okay, so what happened? Dory Mapp was the girlfriend of Archie Moore. Archie Moore was a very successful boxer. He was, for an extended period, he was the light heavyweight champion of the world. And when Muhammad Ali was making his way up the ranks to fight for the heavyweight championship, one of the last people Muhammad Ali fought was Archie Moore. Archie Moore fought until he was almost 50 years old. And I don't mean like Mike Tyson coming back. I mean like Archie Moore fought well into his 40s. In fact, there was always some controversy about his age. His mother claimed that he was younger than he said he was. And he at one point explained that that was because he was 3 years old when he was born. Anyway, so Dory Mapp was involved with Archie Moore. At that point, Don King was in Cleveland, and his house had been bombed. So the Cleveland police started investigating. And I think in part because Dory Mapp was involved with Archie Moore and Don King was involved with boxing. So the police focused on her to see what they could find out. They thought she was a person of interest in connection with the bombing. So they went to her house looking for evidence. And she told them, as one of my colleagues has a sign on his door upstairs, come back with a warrant. And so the officers went away, and a few hours later, they returned with a piece of paper that they waved in front of her that they said, this is the warrant, which she promptly grabbed and stuffed down the front of her dress. And the officers, shall we say, retrieved it. And then they headed upstairs. Now, this is the house, and this is the best picture I can get. And it doesn't really show the relevant part of the house. You can see the front door. But if you look in the driveway, and I tried to get a better angle on this, there is a side door that goes up to the second floor. And that's where Mapp was, right? And when the officers came and forced their way in, they forced their way in the side door, went up the stairs. Now, when they got upstairs, they found some stuff that they claimed was obscene under Ohio law. Mapp argued, first of all, that this wasn't her stuff. It belonged to a fellow she had rented out part of the upstairs to. The police didn't think that was sufficient to distract them from focusing on her. So she got busted for possession of obscene material. And she defended at trial on the basis that the Ohio obscenity law violated the First Amendment. She was convicted. I mean, she did also argue something about the validity of the search, although it was a little awkward to make that sort of argument because at that time, we're now talking about the late 50s. At that time, although the Supreme Court had held that the exclusionary rule prohibited the introduction of unlawfully obtained evidence in federal court, the Supreme Court had also said that the exclusionary rule did not apply to the states. That was a case called Wolf against Colorado from 1949. So Mapp's main defense, although she did say something about the Fourth Amendment, her main defense was that the law violated the First Amendment. It takes the case up to the Ohio Supreme Court on appeal. And if you read the case in the Ohio Supreme Court, you see the court lays out, Mapp says that this law violates the First Amendment for these reasons, right? Here's what the law says. Here's what we think the First Amendment means. She's right. This law does violate the First Amendment. There's a nice discussion at the very end of which there is a quaint paragraph that says, however, only 4 of us, now remember, this is 4 of 7, right? Only 4 members of this court agree that this law violates the First Amendment. Under a provision of the Ohio Constitution that was then in effect, that had been adopted in 1912 as a progressive reform to keep courts who were enamored of substantive due process from striking down progressive reforms, the voters in their wisdom amended the state constitution to say that no, the Ohio Supreme Court could not strike down any law as unconstitutional unless at least 6 of the 7 justices agreed. 4 is not 6, conviction affirmed on this point, right? So anyway, so Mapp winds up appealing to the US Supreme Court. She did in fact raise the First Amendment argument there, but the US Supreme Court decided that it wanted to revisit Wolf against Colorado. And so this is the case in which the Supreme Court overruled Wolf to the extent that it said that the exclusionary rule did not apply to the states, said it did. And by the way, the search in this case was unlawful and therefore the state had no basis for prosecuting Mapp because the evidence, all the allegedly obscene material had been unlawfully seized. So now, for what it's worth, going back to the warrant, the Ohio Supreme Court noted that no warrant was ever introduced at trial, and the court questioned whether that piece of paper that the officers waved actually had been a warrant, although that turned out not to matter to the way the case turned out. Okay, one more, Terry against Ohio. I think most all of you know about this. This is the case that's downtown. You can see Euclid Avenue and Huron going off to the side. This is an old photograph, but I think this old photograph kind of captures what was going on. Okay, there is a historical plaque downtown near here that notes a Detective McFadden who noticed Terry and a fellow named Chilton on a Thursday afternoon. He saw them pacing up and down, first along Huron and then along Euclid. At some point, they stopped to talk to a third guy, a fellow named Katz, who went away. They kept pacing back and forth, and Officer McFadden decided, or Detective McFadden decided that this was suspicious, right? He didn't have probable cause to stop them, right? But he stopped them anyway, and he frisked Terry and felt a firearm under his coat. He eventually took Terry and Chilton into custody. And this case winds up in the US Supreme Court, where and by the way, I think Terry was represented by Lou Stokes, who used to talk a lot about this case because he had been in it, he'd been involved in it so extensively. And I think, as you all know, the Supreme Court said that you don't need probable cause to do a stop and frisk. You just need reasonable suspicion. And although there was certainly plenty of debate about whether the fact that Terry and Chilton were pacing up and down gave grounds for reasonable suspicion, Detective McFadden said, look, I've been doing this for 30 years. This looks suspicious to me. And the courts accepted that. And so that's how this case came along. Now, one last one in the criminal procedure area, that's Shepard against Maxwell. I think most of you know about this case. I was struck by how many people to this day have very strong views about the Shepard case. Now, a lot of the people I know who have strong views think that Sam Shepard was framed. And a lot of other people I know who have strong views are convinced that he killed his wife. I have not tried to sort that one out. I don't, right, but it is striking to me that this case, this murder took place on the 4th of July in 1954. So it's more than 70 years. And we still have people who are strongly invested in whatever version of things they had. Now, so Sam Shepard was an osteopathic physician, and I think whatever actually happened in this case, the fact that Sam Shepard and his father and his brothers were osteopaths has something to do with the way a lot of the professional classes in Cleveland looked at him. My dad was a family doctor who was making house calls in his 80s. He was an MD. Right? You never wanted to get him started on either chiropractors or osteopaths. And I think his views were pretty typical, right? So the Shepards were already looked down on by the MDs, of whom there are so many and have been so many for so long here. So that didn't help. It also didn't help that apparently back in the 50s, the Shepards used to perform abortions for the pregnant female patients of some of their MD colleagues who, because abortion was unlawful in Ohio, would simply do referrals. Again, how much of this, that's all useful background. How much of it explains what actually happened in the case? That's a whole other matter. But now, I'm not sure if this is the actual house. In fact, I understand that the house was later taken down, but this is the location of the Shepard house over in Bay Village, right? And the history is pretty well known. This Shepard was tried in a kind of a circus atmosphere. The Ohio Supreme Court described the proceedings as having been conducted in an atmosphere of a Roman holiday for the news media. Lots of inflammatory coverage. There was a radio station that was given space literally next door to the jury room during the trial. There were wires and mics all over the inside of the bar in the room. In any event, when this case got back to the Supreme Court spent 15 pages simply summarizing the atmosphere surrounding the trial. Now, Shepard was convicted at trial in 1954. The Ohio Supreme Court affirmed the conviction. The US Supreme Court denied cert, although Justice Frankfurter, who used to talk about the significance of a cert denial, Justice Frankfurter wrote a separate statement saying, don't take the cert denial as necessarily an endorsement of what the Ohio Supreme Court did in this case. But that looked like the end of the story until a few years later, a then young lawyer named F. Lee Bailey decided that maybe he could try to get a habeas case going. And in fact, that's how Shepard against Maxwell wound up in the Supreme Court. The court wound up setting aside the conviction precisely because of the inflammatory atmosphere surrounding the trial. Sam Shepard was then acquitted on his retrial. And then, as I recall, he for a time he was a professional wrestler and died in 1970. The last piece of the Shepard against Maxwell story is that years later, the son, Sam Reese Shepard, who was 7 years old at the time that his mother was killed and slept through whatever happened, brought a wrongful imprisonment case against the state. Without going through all of the procedural hurdles, the Ohio Supreme Court refused to decide up front whether the cause of action died with Shepard himself, Sam Shepard, or whether maybe the estate might be able to maintain the action. And without addressing whether there were statute of limitations issues, sent the case back to the lower courts where it was tried. The jury came back and ruled against the wrongful imprisonment claim, at which point Sam Reese Shepard's lawyers appealed to the 8th District, and the 8th District then concluded that the claim was personal to the defendant, Sam Shepard, and in any event, it was years too late because we were now talking about more than 30 years since Sam Shepard had been acquitted at trial. Okay. Now, I want to talk a little bit about the First Amendment, partly because I spent years teaching the First Amendment. And I'm not going to spend a lot of time talking about Jacobellis because Judge Gallagher did a wonderful job last year talking about this case. And I really can't add much to what he had to say. But let me at least, this is the old Centrum Theater building, which is where the movie was shown. A couple of things to think about. A friend of mine who clerked for Justice Potter Stewart said that Justice Stewart said in the interview that he was convinced that he would go to his grave remembered only for having said in Jacobellis that I can't define obscenity, but I know it when I see it. And the movie at issue in this case is not it. Fair enough. Now, Jacobellis is not a great case, except maybe for that line. It's a 6-3 ruling. There are 4 separate opinions siding with Jacobellis, none of which is subscribed to by more than 2 justices. And one of the 6 justices simply says, I side with Jacobellis, but he doesn't say a word about why, right? So I know it when I see it may actually capture what was going on in this case. Now, I should say, just from my perspective, I have a little connection to this. I had never seen the movie in this case, Les Amants, The Lovers, for years and years and years, until the Cleveland Heights Historical Society brought the movie back to mark the 50th anniversary of the bust. And so I called over to the Historical Society to see if I could get some tickets for my wife and my mother-in-law and me. And when I told them who I was, they said, would you talk about the case? I said, on one condition, and that is that you let me bring Peter Krause, who was at that time a Plain Dealer reporter and is now writes for Cleveland.com, because Pete Krause had apparently found out about my tour and that the Centrum Theater was on it. He was doing a big story about the case, about the bust. And so he came to talk to me. We had a good conversation. He didn't really need to talk to me. He had a whole lot already. But he drove me up to Euclid Heights Boulevard, parked there, stood me in front of the theater, and had a photographer snap a picture of me under the marquee, which ran on the front page of the Plain Dealer, below the fold. And for several months afterwards, some of my colleagues referred to me only as the porn king. So, okay. But for more substance on this case, I really do commend you to Judge Gallagher's talk last year. I've seen it. I thought it was terrific, and I don't want to step on his lines. One more. This is one of my favorite cases of all time, Lehman against the city of Shaker Heights. And this is not only because I used to live in Shaker Heights, although I did. I actually was intrigued by this case long before I got to Cleveland, because this is, how can I put it? This is one of the very few cases, maybe the only case I can think of, in which the Supreme Court essentially said political speech has less First Amendment protection than any other kind of First Amendment protected speech. Here's why. Shaker Heights used to operate its own rapid system. It's right, the blue and green lines are now part of the RTA, but they were, for decades, they were run by the city of Shaker Heights. And the city of Shaker Heights had a policy prohibiting political ads on the rapid. In 1970, a young Jones Day lawyer named Harry Lehman ran for the state legislature. He was running, by the way, against an incumbent who was a young Baker Hostetler lawyer named Richard Hollington. Richard Hollington's daughter was in my very first class. I think I may have I know I met Harry Lehman a couple of times. I think I met Richard Hollington some years later, but anyway, so Harry Lehman wanted to buy some space on the rapid cars for a campaign card that was going to say something like, Harry J. Lehman is old-fashioned about honesty, integrity, and good government. That was it. By the way, if you're interested in seeing it and you have a chance, go into our law library, go up to the third floor of the library by the stairway, and we have one of those cards because Harry Lehman donated his files on the case to us, and that included the advertisements. In any event, Lehman had to go to the U.S. Supreme Court, where he lost in a 5-4 decision that had no majority opinion. The plurality of 4 said that the city of Shaker Heights was engaged in a proprietary, not a governmental activity, and therefore the First Amendment didn't apply at all. The 4 dissenters said, this is First Amendment activity. The city has opened a public forum by saying that it will accept advertising for essentially any lawful product or activity except political speech. And under public forum doctrine, you can't make those sorts of distinctions. The crucial vote, the deciding vote, was cast by Justice William O. Douglas. This was I think his last full term on the court, and he did some other peculiar things that term. Justice Douglas decided that the city should win because he thought that the passengers were a captive audience and could not look away. And in support of this, he cited one of his own dissenting opinions from about 22, 23 years earlier. It turns out that the old DC public transit system used to run audio on their trolley cars. Justice Douglas used to take the trolley from his home to the Supreme Court, and he was infuriated about this because you couldn't cover your ears, right? Okay, I get that. There's no audio on Harry Lehman's side, right? But that was the basis for Douglas going along. Okay, now, all right. Now, Harry Lehman won anyway. He served 10 years in the legislature. He chaired the House Judiciary Committee for a good chunk of that time. And then he opened and managed the Columbus office for Jones Day for many years. Richard Hollington went on to a distinguished career at Baker. He did return 40 years later to the legislature. He was appointed to fill the unexpired portion of Matt Dolan's seat in the legislature when he resigned to run what turned out to be unsuccessfully for Cuyahoga County Executive. And Hollington thought he was going to be done at the end of the term, but it turned out that Tim Grendel, who is now in the news for other reasons, Tim Grendel had been elected to that seat, but he was already in the state Senate, and after the election, he decided he'd rather stay in the state Senate, and so there was a vacancy that Hollington managed to fill for a while after that. Now, one more, City of Lakewood against Plain Dealer Publishing Company. This is actually a challenging case on the tour because this is a case about newspaper vending machines on public sidewalks. And let's just say it's been years since there were newspaper vending machines on public sidewalks. But basically what was going on in this case, and here's the Lakewood City Hall, the ordinance in Lakewood said you couldn't put a vending machine on a sidewalk without a permit from the mayor, but there were no standards in the ordinance to explain what grounds the mayor could use to turn down an application. And so the plain dealer took this to court, and the US Supreme Court said, look, this is a classic First Amendment violation. It's a licensing scheme that gives unfettered discretion to the administrator, right? It's not a unanimous decision only because what's at issue here is the public sidewalk, and some justices thought that this was a little bit different because it's the public sidewalk, which would be essentially permanently occupied by the vending machine. But nobody disagreed that the ordinance lacked standards and that was a real problem. Okay, now let me close with two cases involving, well, they're due process cases, or they were decided as due process cases, but they actually involve the Cleveland School Board. The first of which is the LaFleur case. And this, by the way, this is now the Drury Hotel. It's the only photograph I have. But this used to be the old Cleveland Board of Education building. So just bear with me and imagine that this is the board building. Now, LaFleur is a wonderful case in a lot of ways. And there are a bunch of connections between the case and this law school. But basically, the Cleveland School Board had a rule, fairly common rule. Pregnant teachers had to stop working in the classroom at the end of their 4th month. In other words, before they began to show very much. And the teachers could come back at the beginning of the first term after the baby turned 3 months old. So there are two teachers in this case, Joe LaFleur, who was pregnant and told she had to stop teaching. And then there was another woman named Ann Nelson, a pregnant teacher who also was told she had to stop teaching. Ann Nelson was married to one of our students, and her husband came to one of my colleagues and said, what do we do? And that wound up getting my colleague Lou Katz involved in the case. Lou represented Ann Nelson, Carol Agins represented Joe LaFleur, and also another connection upstairs, Lou's sweet mate, a fellow named Sidney Picker. Sidney's wife, Jane, taught for many years at Cleveland State. They were both involved with the Women's Law Fund here in Cleveland. And so when the case went to trial, Carol Higgins and Lou Katz were representing the teachers. And Lou has a story about going to a pretrial conference with the district judge. And when Lou came in, the judge said, "Good morning, Professor Katz." And then when Charles Clark, the Squire Sanders partner, who was the lawyer for the school board, came in, the judge said, "Hi, Charlie." And so, Lou said he figured it was going to be an uphill battle, and let's just say they lost a trial. They won at the Sixth Circuit, and the case was argued in the Supreme Court. Jane Picker argued the case in the Supreme Court, and she argued it as an equal protection case. She said, women are being treated badly because they are women. And that's a classic equal protection violation. Well, the Supreme Court then, and to some extent now, has had a lot of trouble thinking about pregnancy in equal protection terms. The same term that the court decided in LaFleur, it decided another case called Geduldig against Aiello, in which the court said a classification based on pregnancy is not gender-based. It's a classification between pregnant women and non-pregnant persons. I am not making this up. In any event, so the court, as I said, the court had a lot of trouble with this, and so the court clearly was uncomfortable thinking in equal protection terms, and so it treated this as a due process problem. That is to say, this was a conclusive presumption that all pregnant teachers were unfit to work after the 4th month, and that, the court said, was unacceptable. You needed to have some sort of individualized determination. Right? Not what Jane Picker argued, but a win is a win, as they say, right? Okay. Although I will tell you that the Supreme Court, for good reason, fell out of love with conclusive presumption analysis not long afterwards, which raises the question: how would this case have come out had it been litigated a few years later? Last case is Loudermill, also the school board. Loudermill was a security guard who had said on his job application that he had never been convicted of a felony. It turned out that he had been found guilty of grand larceny, which he claims he thought was a misdemeanor, not a felony. I'm not going to vouch for the man's credibility. I'm just telling you this is the claim. Okay. Eventually, the school board discovers that he had this conviction, and they fire him for lying on his job application summarily. And they say, "Oh, you can have a formal hearing after you're fired, but you can't have anything before." Well, it turns out that Loudermill made a due process argument, right? And local connections, right? You all know, in order for due process to be triggered, you have to have a liberty or a property interest, right? And a property interest is created by an independent source like state law. This all comes from a case called Board of Regents against Roth, and there's a local connection to that too, because Steve Steinglass, the longtime professor and then dean at Cleveland State, argued the case in the Supreme Court on behalf of Roth. And by the way, one other small plug for Steve: if you have not seen his book on the Ohio Constitution, you should. Shameless self-promotion, I just published something in the Cleveland State Law Review, etc., which is their online supplement, about the book. The title of my piece is "The Last Word on the Ohio Constitution," and I think that's a fair summary of the 17 pages of verbiage that follows. So check out Steve's book if you don't know about it. Anyway, but it turns out that the U.S. Supreme Court had suggested in a plurality opinion some years afterwards, a case called Arnett against Kennedy, that maybe the state could define not only the nature of the property interest, but the procedures for its vindication, right? On the theory, the court said that you have to take the bitter with the sweet. It's the whole package. That part of the case, Arnett against Kennedy, was a plurality opinion. And so Loudermill is important because the court said, no, Arnett is wrong. The state gets to define the substantive property interest, but that's a matter of state law. But the means for vindicating that state created interest, that's a federal matter. The state can't give with one hand and take away with another. And so the fact that the school board was willing to give Mr. Loudermill a pretty elaborate hearing months later couldn't make up for the fact that they gave him no process whatsoever before they fired him. Okay. Now, we need to stop because you have to go on to some substantive things. I want just to, first of all, to thank you for your patience, but I also want to say there are other important cases that arose around the Cleveland area. I've talked about these cases because they're the ones I used to do on tour, but there's a whole slew of other important cases that are worth thinking about. You know, there's the Debs against the United States, which took place in Canton, was tried in the federal courthouse downtown, Eugene Debs's condemnation of World War I. And there's Scheuer against Rhodes, which is an important immunity case that grew out of the Kent State shootings. One of my favorites, Zucchini against Scripps Howard Broadcasting. Zucchini, if you don't know, Zucchini was a celebrated circus performer. He used to get shot out of a cannon. I remember my grandparents taking me to see him. Well, it turns out Channel 5 ran a clip of him being shot out of the cannon on the 11 o'clock news at a time when he was performing in Northeast Ohio. And Zucchini sued, claiming that they had essentially appropriated his entire act. And it wasn't literally everything, because he, it was like a 15-minute act, which they had reduced to about 45 seconds, but it was the part where he gets shot out of the cannon, not the buildup, right? Okay, so the Supreme Court says, oh yeah, the First Amendment doesn't preclude a right of publicity claim here. And there's also the Cleveland school voucher case, right, Zellman against Simmons Harris. I mean, so there's a whole slew of these things. But one of the things that strikes me even now is how many really significant cases have arisen in Cleveland compared to lots of other places. And I think that it's a good thing to be able to say this stuff happened here, whether we agree necessarily with how all these cases came out or not. At least these are really useful, significant things, and we can point to them and say we have some sort of connection. So thank you for your patience. I'm happy to take questions in the minute and a half or so that we have left.
What do you think accounts for a relatively high number of cases? Is it because we have such a legal community relative to our population, or is there some other reason?
I'm not sure. I mean, keep in mind that at the beginning, Cleveland was one of the largest cities in the country. It was an economically really significant kind of place. And I also think that in some instances, we just had folks who were thinking about some of these issues. I mean, many of these cases were litigated by really good lawyers. And, it's hard to get to the US Supreme Court if you're not a good lawyer. But I don't know. I mean, I think about the only other city that comes to mind as being, like a large number of big cases in modern times is San Antonio. There's a major 10th Amendment case. There's a major school funding case, Rodriguez, right? The 10th Amendment case is Garcia against San Antonio Metropolitan Housing Authority. And then there's a big case about the Religious Freedom Restoration Act, City of Bernie against Florence. Bernie is a suburb of San Antonio. I don't have an explanation for that one either. But as I said, I'm hard pressed to think of very many other cases that even any other cities that have that many. So, maybe it's just a coincidence. Maybe there's some deeper explanation. I'm open to suggestions.
Something in the water.
Well, I think we need to move on. Is that right? So, thank you.